Hi everybody, this is attorney Robert Pascal, and I am back today to discuss with you about establishing a business in the United States without an investor's visa. The reason why I wanted to discuss this topic today is because I have a number of clients that have come, they've met with me, they're really eager to make an investment in the United States, but unfortunately they do not have the eligibility to meet the financial threshold to qualify for an investor visa. Now, there is a way to go about establishing a business in the United States without an investor's visa, but I have to tell you that it does come with a great number of limitations. So, as far as being able to establish this business in the United States, my recommendation is first you're going to need to come and visit the United States. The easiest means of being able to do that would be to apply for what's called a B visa. This is basically a category of a non-immigrant visa that's issued by the United States government to foreign citizens that want to come into the United States for a temporary period. There are actually two types of B visas. The first of which is the B1, which are issued to those people that are seeking a entry for business purposes, and then the B2 visa, which is issued to those for entry for tourism or other non-business purposes. Really, in practice, the two visa categories are usually combined together, and they're issued as either a B1 or a B2 visa, valid for a temporary visit for either business or pleasure, or the combination of two. Now, if you look at the USCIS website regarding B visas, the website does state that you may be eligible for a B1 visa if you are participating in business activities of a commercial or professional nature in the United States, including but not limited to the following. Okay, this would be consulting with business associates, traveling for a specific scientific, educational, professional, or business convention or a conference on specific dates, settling an estate, negotiating a contract, and participating in short-term training. As to the eligibility criteria, you must demonstrate the following in order to be eligible for a B1 visa. You have to demonstrate that the purpose of your trip is to enter the United States for business of a legitimate nature. You plan to remain for a specific limited period of time. You have the funds to cover the expenses of the trip and your stay in the United States. You have residence outside of the United States in which you have no intention of abandoning, as well as having other binding ties which will ensure your return abroad at the end of your visit, and then you're otherwise admissible to the United States. Now, it's very important to note what the limitation of this B1 visa is. You can come in, you can set up a corporate entity, you can lease office space, hire employees, obtain a tax identification number, and open a corporate bank account. You are not, you are not permitted to work for or obtain compensation from the U.S. corporation while you are physically in the United States. So basically what you're going to be doing is you're going to be really classifying yourself as what's called a passive investor. A person who is lawfully residing in the U.S. with U.S. either citizenship or permanent residence or authorized employment status will need to be hired by you to help run the day-to-day operations of your company or business. You can, perform work for the company while you are outside the United States. You can derive profit payments from the U.S. corporation too. Now, if you decide to visit the U.S. on a B1 visa, your stay is only to be limited to a period of 6 months, and I do not recommending any type of filing of extensions of stay. Any extended periods leading up into 5, Months on a B1 and even a B2 will subject you to heightened scrutiny upon return to the United States. So, if you're given 6 months, I really at most would advise only staying for 3. U.S. investment income is generally taxed at a flat rate of 30%. That has actually been reduced to 21% with the passage of a new tax law bill in the fall of 2017. So, it's important to know what the consequences of you violating this B1 status. If you open a business in the U.S. with a B1, you must be extremely careful not to violate the limitations of that B1 visa. So, for example, working and getting paid by the company while in the U.S. will definitely be a violation. If you do so and you are caught, you will be deemed to have committed visa fraud, which subjects you to large penalties. For instance, unlawful employment in the United States will result at least in 5 years of inadmissibility. If they move you into a category where you've committed visa fraud, then your chances of return will be extremely slim. So, keeping that in mind, please feel free to either email me or you can contact my office number for a consultation. Again, I thank you and have a good day.